Well, the High Court has ruled today that Aboriginal people cannot be deported for criminal convictions, born here or not, citizen or not, and even if their claim to Aboriginality relies on family members 2 or 3 generations back. This historic judgment issued today comes after the federal government sought to deport 2 men, both born overseas and who never took up Australian citizenship, for serious crimes committed in Australia, crimes that include assault, bodily harm, domestic violence offences, theft and drug offences. Prior to being deported, both men say they identify as Indigenous, and the High Court found that they are not subject, therefore, to the alien powers in the Constitution and can't be deported under immigration law. Chris Merritt is the Australian newspaper's Legal Affairs editor, joins me now live from Sydney. Chris, this is an extraordinary judgment. It's a very powerful judgment. It is not a majority judgment in the sense that it was universally adopted by the court. It was a split decision, still majority decision, 4-3. What do you make of it today?
I think it's shameful. It's elevated a racial distinction to a point of constitutional privilege that would never be accepted if it were put to the people at a referendum. And that's what should happen. If the High Court decides or believes that non-citizens, Aborigines, should not be deported simply because of the fact that they've got a particular race, that should be put to the people at referendum. It's a policy decision. It sets a dreadful precedent. It elevates race to a point that has no business being in the highest, the governing body for Australia. It limits the ability of the federal government to protect all Australians from foreign criminals. Now, bear in mind, these 2 men were born overseas, Papua New Guinea and New Zealand. They are citizens of those countries. They are not Australians. They never took up Australian citizenship. They've been here for some time and didn't take it up. There's a huge inconsistency in the High Court's logic. The basis for the majority's decision, and this is spelled out in the summary that's issued by the court, is their special connection with the land. And they talk about how this special connection is held by Aboriginal Australians, and it's inconsistent to then treat these people as aliens. The point here is that...
Let me just jump in there, because I want to, you're right, I want to quote that point because I marked it out myself. The court declared that Aboriginal Australians have a special cultural, historical and spiritual connection with the territory of Australia. Now, granted, and this is by the men's admission, it's in the court documents today, one man, Thoms, a New Zealander, has his Aboriginality confirmed via a maternal grandmother. The other gentleman, Mr Love, the PNG born man, has his Aboriginality confirmed by paternal grandparents. They are saying that biological connection trumps all the laws that parliaments might make, and indeed, as you point out, trumps the Constitution.
It's worse than that. Who makes a decision on who is an Aborigine? The court has confirmed that what they call as a tripart test for Aboriginality. There must be a biological element, there must be identification by the person concerned with the Aboriginal community, and that must be reciprocated. So a key part of the test for Aboriginality depends on the Aboriginal community, leaders of that community or those in authority within that community. Now, why is that important? Because a decision by that group can render null and void a critically important part of migration law. So instead of the federal parliament or the people of Australia deciding how migration law will work and whether certain criminals are worthy of being deported, this decision changes that, and for Aborigines it vests that power in the Aboriginal community. Now, to be fair to the High Court, it was a split decision, 4-3. Had one judge gone the other way, it would have been a completely different decision. And it's worth pointing out that one of the most powerful dissents in this decision was from the Chief Justice, Susan Kiefel. Anybody who has doubts about the abilities of the High Court to keep their feet on the ground should read Susan Kiefel's dissent. It's a lecture that should have been taken on board by the majority, which is, I'm stunned that it wasn't. The precedent this sets is really troubling. There will be those who say, oh, look, there's very special circumstances. These people were, it's confined to its facts. But that's not the point. The point is that the High Court of Australia has made what is inevitably going to be seen as a racist decision. They've elevated race, the race of an individual, to a critical level in the Constitution. How long will it...
Let me play, and on that point of race, there were comments very quickly from the Greens. Nick McKim, the senator from Tasmania, fronted the media. He claimed the very act of trying to deport these men, these non-Australian men, was itself an act of racism. But I agree with you, Chris Merritt, that in fact deciding that they can remain and that they trump the law of the land by very virtue of their race is what's racist. Let's have a listen to Nick McKim.
It does raise the issue of on what planet, a white minister could make a decision to try and have an Aboriginal person declared as alien in their own country. It says an awful lot about the government and the minister that they would take a decision to effectively try and deport someone from land that we in effect stole from them 200 years ago, and it's very hard to see this decision in any other context than a racist decision by government.
Just on that point, Chris Merritt, is there any limit to how far an individual can go back? Let's say they've lived in Canada for 4 or 5 generations. They might have a relative somewhere in the family tree who can legitimately claim Aboriginality. Can that be used in the context of this decision, do you think?
It will certainly be tested in the courts. The tragedy of this is this decision can't now be overturned by Parliament. This is a constitutional decision. It can only be overturned by referendum or by a future High Court. It's with us. The other point that's worth mentioning is that this decision is a grave disservice to Indigenous Australians. It will be used to emasculate the arguments of those, like myself, by the way, who have argued for an entrenched voice for Aborigines to Parliament. The fact that race has been expanded in such a ludicrous manner by the High Court will mortally damage the case for a voice to Parliament.
And it won't be just immigration matters that this now will sit across. It will be used, I suspect, across a myriad of legislative arms, not just immigration and tests of whether to deport or not.
Look, there's plenty of lawyers who have been watching this. It's inevitable that this precedent will be used. If it's good enough for race to be a determining factor when it comes to migration law, what about other areas of law? What about family law? What about crime? It's an open question now. That the genie is out of the box. It's a really retrograde decision.
I'll have to leave it there, Chris Merritt. I don't think at all that this will be the last time we discuss this issue. As I said, a historic decision today, and one that will be poured over by the community as much as lawyers, I have to say, in the coming days and weeks. Thanks very much for your time tonight.